Quick intro and some disclaimer. As Bijan mentioned, I teach a course at Cornell Tech. The latest one I taught were entitled AI Law and Regulation that had grad students, including JD, LLM, MBA, as well as Master of Computer Science. Before that, I taught a course on blockchain law and regulation, which I found interesting. Um, Full disclosure is that I'm a US lawyer, and a lot of these discussions will be US based, but we will go into global regulatory developments I find interesting. It's not possible to track everything that's going on in every country, but we're going to focus on US, EU, as well as UK, because they often set good framework for other countries to follow, with the exception of maybe Japan. The goal is to provide a high level overview. And lastly, I'm not your lawyer. So it is not the purpose that I'm here to give you legal advice, but to give you legal knowledge and some concepts around these. Okay. So from product perspective, I put this diagram in here. And again, I'm not a technical or product person, but I always like to look at legal issues from product standpoint. Maybe I'm a product counsel at heart. And the reason for that is it helps you identify risks and issues more crisply than if you don't view any sort of law and regulation from product perspective. So we're going to keep coming back to this very basic diagram, right? You got the input, you got the data, you got the product, API, you got the model's fine tuning, you have an output. And we're going to determine which law applies to which parts, because let's, pick a law. It might apply to 3, 4, 5 different parts of this product components. And I think it'll be helpful for folks here as they try to unpack different legal considerations and understand how they're impacted at different parts. We're going to cover 3 big areas today. First is intellectual property. Second is data privacy. And third is regulatory developments. One last disclaimer. So I taught a full course on these 3, and I felt like I ran out of time. So I was thinking to myself, how do I make this useful for folks here in 45 minutes when I couldn't cover everything I wanted to in 6 months? We're going to keep it very high level, but try to make it as interesting as possible. So let's do it. Oh, and Bijan, if there's any question, I'm not sure if I could see it. Please feel free to jump in and interrupt me if that's okay.
Sure thing. The one thing that I asked the community to they can type their questions in the chat, and then we'll answer them at the end. This way, Joon can go through his flow, and we'll still have time to answer questions without interrupting the flow.
Thank you. Okay, so before we go into the first area of law, I think emerging technology has really interesting issues. And this is not just for AI, but for blockchain or other emerging technology as well, which is the growth of technology is exponential. Well, Joon, AI has been around since 1940s. It's always been around. But again, I focus on the growth and adoption, right? And oftentimes, the group of people who pass law or who are in charge of applying law to technology, their understanding of technology is not very high. So you have this issue for every emerging technology where existing laws exist and apply to technology, but those laws were created years and decades ago without considering that particular emerging technology. So oftentimes, somebody like myself, my job is to marry the two and identify which gray areas exist. What is a product decision that puts you on the wrong side of the fence versus the right side of the fence when we're thinking about existing regulations? Interestingly enough, EU is ahead when it comes to AI regulation, and we'll touch on what that means and how that could apply to your company or your future company. Because people will say, oh yeah, it's an EU law. Well, if you have customers in EU, you could be scoped in. So there, these are very territorial sort of concepts. We'll go into those. But again, existing laws, new technology, how do we bridge, right? That's a big concept here. The first is intellectual property rights. 5 major ones in the US are copyright, patent, trademark, trade secret, and rights of publicity. Before going into the law, I always like to explain what they are in a layman term and why the lawmakers created protections for each of those. And understanding the policy behind the law is often more important than knowing the law itself. So let's go into those. First is copyright. I would say majority of the IP issues you see in today's world relate to copyright, as they relate to AI. It's not necessarily patent, trademark, or other areas, but it's copyright. And we'll go into why that's the case. Let's focus on kind of the basics of what a copyright is. The 2 words you have to remember for copyright are creative and expressive. The law, US Copyright Act, is a design to protect creative expressions, not inventions, not function, not utility, anything, right? Creative expressions are protected under copyright. When is the copyright protection kick in? At creation. So when you create a work product that is copyrightable, you automatically get attached a protection in the United States. And that is a very powerful law, right? Not a lot of laws are like this. When does it end? About 100 years. It's more or less 95 years. For instance, Mickey Mouse, their Copyright Act expired earlier this year. So it went into public domain, and anybody could draw Mickey Mouse. Anybody could incorporate that into their company pitch decks or whatever, and Disney cannot sue you for it. But 100 years is a long time, right? And it gets automatically created. It's very powerful law. Okay, do you have to register? No. You do not have to register copyright in order to receive its protection. It is optional, highly recommended that you register because it creates a public record for you to create enforcement. And oftentimes, registration forces companies who are using it for commercial reasons to reach out to you and say, hey, we need a licensing agreement, right? So from a practical standpoint, registering is a good idea, but from a theoretical standpoint, you do not need to register to invoke the power of copyrighted protection. And lastly, policy. It's an expression, not a function. And some of the work that you could typically think of as receiving copyright is books, articles, papers you write, and for purpose of today, software code. Code you put on GitHub repo, your websites, they're all copyrightable. And you could actually invoke this protection to protect it against misuse of your work product. And let's compare that with patent, right? And patent is completely different. It's under a different federal statute, and it is designed to protect invention. It's very narrow. So when you work with a patent lawyer, they're some of the best wordsmith I've ever met. And you have to be so specific in each of the claim and patent application that, you kind of wonder, how do you even do this unless, you have a really good idea of everything else that's available out there, which is a huge field. The keyword here is invention that are A, new, B, non-obvious, C, useful. So if I want to create a patent on a fork, and that fork has an extra pointy thing versus other forks that are available, that could be new. That could be useful because it grabs more food, but that's very obvious. So that'll fail the patent test. As an applicant, these are the 3 things that you have to prove to receive a protection for. The protection kicks in at registration. So it's not automatically attached. and it only lasts for about 20 years. There are different variety of patents, and each of the patent, whether that's like business patent or like a biopharma sort of biology patents, they all have very specific nuances on how to draft claims and how to enforce. But the idea is generally 20 years, your patent expires. Registration is required, as I said, and usually it's a long process in the United States. I don't know if people here have had experience, but it generally takes 2 to 5 years. And if you want international patent, granted, there is an expedited process for that. It takes longer. So business owners often have to worry like, okay, I can't open source this. The moment I do it, I lose patent protection for it or my ability to claim. Then how do I talk to folks about my work product? How do I protect it so that I could receive a patent protection, but still get people interested as investors or customers or vendors? Those are always tricky questions. And policy here, lastly, is it's not an expression, it's a solution that people are going for, right? And it has to be oftentimes very technical. The third one is trademark. Trademark, it's like the logo, it's the brand, it's the word, sometimes it's the font, sometimes it's the color. The jeweler Tiffany, trademark their signature Tiffany blue, light blue, right? So there's a lot of different things you could trademark, but the idea is you've spent a lot of time building goodwill around an expression, right? Whether it's a logo or a word or a name, and you don't want that misused by people who don't have the permission to use it. So distinctive brand is the key word, and you get protection for it when you use it in commerce for the first time or at registration. So it's a little bit of a difficult concept in the United States, but there's a common law protection for trademark, and there's the statutory protection for trademark. If you register, you fall under statutory and you have a lot of right, and you could enforce quite a bit. Even if you don't register, you could make a case in a state common law saying, I used it in commerce, I should be entitled to it. But that's often a harder route because you got to research, you got to hire lawyers, you got to research state law, you got to understand what does commerce mean in this state, what does first use mean. So oftentimes it's highly recommended to register at a federal level. And date of demise, last used in commerce plus 3 to 5 years. And the registration process for trademark is faster, 6 months to a year, I would say. I haven't really seen a lot of trademark that exceed 12-month mark unless you're arguing with the USPTO about specific coverage of trademark. And lastly, the policy is use it or lose it. Last IP is rights of publicity. Not a lot of people know about this. Basically, anything that's very personal to you in nature, you almost get this constitutional, and it's not really constitutional, but you almost get this constitutional protection for it. So if I wear Bijan's mask or I sound like Bijan and I pretend to be him, it's like you're protected in that way, right? So the keywords here are traits that are very personal in nature that are not that shouldn't be misused. When does it kick in? When you're born. When does it go away? It's not at your death. So like there's all these estates like Michael Jackson or celebrities, they still have the right to go after people for rights of publicity of the deceased. So it's not necessarily at death. Registration, no, just like copyright, it automatically attaches. And policy is always ask for permission first. The case that will be very famous will be Scarlett Johansson versus OpenAI. There's this huge drama about using her voice. And I could guarantee you that rights of publicity will be an important legal discussion for that case. Oh, let me go back. Okay. So again, I go back to this product, what I call product roadmap or components. Sorry, I don't want to misuse a product word and get in trouble. But let's just go back here, right? Like the most, prevalent discussions of IP in the United States is copyright. So how does that fit in to the product components? User input, are you using information that is copyright protected? Training data, are you training your model using copyright protected? Do you have a licensing agreement? Do you have a data sharing agreement like the one that OpenAI just entered into with Apple? Is a model itself violating copyright? Are you using a model that's too similar to another who has that protection? Is the output invasive and also potentially infringing copyright? Is the result looking so the same as a copyrighted information that you have to worry about this? So copyright could show up its ugly head in so many different areas, and this is very high level. Like I'm sure there's more, but this is an example of how one sort of legal jurisprudence could pop its head in different parts of the work. So let's go into the law. I think the case I like to always start is a DC Circuit Court case where basically a lot of law firms will base their advice on, right? And the idea is, first of all, judges, they don't like technical stuff, especially federal judges. And jury, they don't understand it. And the moment you introduce a new tech and the judge has to bend, laws to apply to it, their initial reaction is, what's this? If you don't understand it, you kind of run away from it, right? We're seeing a little bit of that in the United States. So this case basically says if an AI creates a work product, it's a big uphill battle to receive a copyright protection for it because it requires human authorship. That's the element. But what does that mean, right? What does it mean to be a human author of an output? Does that mean that you've, put in a prompt? Does it mean that you've started taking an initial output and created a copyright work? Like how much revision is enough to satisfy human authorship, right? Like, can you use an AI model multiple times? Can you have a different people make modifications to it? Everything is not clear. And I think it's going to be very case by case. Like whoever brings the case to these courts will have to argue from policy standpoint why these are okay and some are not. I always like to tell students, if you want to look at what's the most newsworthy, follow the lawsuits. And I think you'll notice a trend here. So first case is a California case of authors alleging OpenAI infringed copyrighted book materials when trading, ChatGPT. Second is visual artists suing for similar things to different sort of visual AI systems. Third is Authors Guild, similar to Tremblay, arguing that, I have books and I have copyrighted works and you can't use that to train your models. You're benefiting, basically. Next is Getty Images, which is huge, alleging that Stability AI's model used copyrighted images without any authorization. Last word is New York Times versus Microsoft, saying you've used our articles to train chatbots. Now, if we go back, you're seeing a lot of action happening in training data, right? That's where some of the biggest litigations are. But again, I warn people that those are the litigations that are coming up in news. And not all of these lawsuits are picked up by news. So other areas matter as well. But I find it interesting right now that training data is the hottest topic when it comes to copyright. Okay, I would be remiss if I didn't talk about fair use when I talk about copyright. So what is a fair use? Fair use is kind of like a defense. So if you murder somebody, but you could prove self-defense, that is a defense. That doesn't make murder any better, but you're basically saying I was justified. And fair use is like that. You could basically violate copyright rights of others, but if you could prove fair use, you could basically say, I did it and it's fine. What is a fair use? Basically, you could read this, but how I like to break it down is, let's say you use some copyright work, some non-copyright work, and the output is transformative. And transformative is a very legally loaded word. And that sort of has a good impact on the market, or doesn't hurt the market value of the copyrighted work that were incorporated. If you could prove that, you have fair use. But again, I'm summarizing quite a lot, but that's sort of the gist of it. Now, the problem with that is sometimes it's very hard to determine the proportion of the data used, right? So if for instance a model use 80% copyrighted work, that's not going to be okay. That's too much copyrighted work. And oftentimes, LLMs have this black box problem. So how can you go back and say like what portion of the output, are attributable to what input? So it's been very difficult for a lot of AI companies to argue for fair use. Just FYI, but it's a defense that is available. Patent. So patent's important. You get patent on a bunch of things. You could, get patent on the model itself. You could get patent on, an output, mostly. But I think it's important to know that USPTO share US Copyright Office sentiment or jurisprudence. Only a natural person can be listed as an inventor, and this is same in UK. That means that if you use a AI system to create something and you apply for patent, that's not gonna receive a patent protection. Now you could ask Joon, like, how would they know? I don't know. I think those are all interesting questions that have to be determined, but natural person has to be the inventor. However, interesting question is, again, where does it blur the line, right? If I use ChatGPT, or if I use an AI system to create the initial draft of the claims, but I worked with lawyers to really improve upon it, is that human authorship or is that natural person? We don't know yet. And oftentimes, if you get a question from USPTO, you're in a situation where you have to defend it. This USPTO guidance is fairly well shared. It's aligned with UK as well as EU, so just FYI. And again, I want to highlight that the moment you make a public disclosure of a work product you want to apply a patent for, you're not going to receive a patent protection for it. Basically, you're giving up. So a lot of times, a lot of these LLMs are like open sourced, no patent. If it's proprietary, then you could receive a patent protection for it, or trade secret. Oops. Did I mention trade secret? I might have missed. Okay, I missed trade secret, so I'm going to cover it really briefly. So yeah, like you could get if it's proprietary, closed source, trade secret, or patent. Trade secret is kind of like the most famous example is the recipe of Coca-Cola. Nobody knows, and that's because they've done their job. They have it in a vault, or only like one person knows. Basically, the idea with trade secret is that you hold it so protected that the law recognizes how important it is. And if you use trade secret and you sort of say, hey, I want to go after somebody for stealing my trade secret, litigation usually plays out such that you have to prove the efforts and the amount of actions you have taken to protect the recipe, the know-how, the whatever, in order to establish trade secret. So oftentimes the output could be patentable or it could be trade secretable, and the steps necessarily to obtain protection very different under the two. It's always important to have a good IP lawyer that takes a look at that. Okay. So that's IP at a very high level. And sort of some predictions for IP here is that IP is not as well advanced as data privacy, at least in how that might be applied in US or EU. And I could see a lot more court cases, not necessarily statutes, addressing some of these nuanced AI issues. But one thing I do know about courts is that they're very slow. So there's going to be tremendous gray area between now and jurisprudence that, opines on these issues in terms of how or what you need to do in order to protect or in order to use certain data, right? So if there's one area that you want to really invest is the IP law when you're running a business relating to an AI system. And again, I could be wrong, but unless there's a sweeping federal legislation, it's going to be up to the court, it's going to be up to jury, it's going to be up to circuits that differ opinions. So just FYI. Okay, data privacy. Just going to look at the chat. Okay, so I'm going to go back to these at the end. All right. Okay, so data privacy, super complicated, but the idea here is you can't use data of third party or your customers unless you really thought it through, right? And it's far more advanced than IP in terms of law. US legal landscape, very messy, super messy. So I would say the primary regulator of data privacy in the United States are state regulators. And state privacy laws are very advanced. But more important to think about this is not state privacy law, because like if you launch an AI business, you have quite a lot of states. So how many state laws do you have to worry about? Like, do you have to hire a law firm of each of the 50 plus states and do an analysis? Nobody does that, right? Rather, a more pragmatic approach is, what is it that you're building? And is there a subject-specific data privacy law around it? So CCPA or HIPAA, like children privacy or patient information. Those have specific federal and often state statutes, and focusing on those are probably a better worth of your investment than general state privacy law, right? So that's just a very high level opinion on it. Employer use of AI. New York recently passed a law on that. Still a lot of bills about AI relating to privacy are being discussed at different states, but they're very in a what I would call research stage. So whether it's the governor or whether it's the state legislators, they've basically said, create a study group and find out what we need to do. At a federal level in the United States, there is no federal privacy protection law. And this is very different from EU, which has GDPR. There's another law called Algorithmic Accountability Act, not passed. And this year is an election year, and it is highly unlikely that anything sweeping will be passed this year. I think at the earliest it will be next year, depending on how the political outcome is. And I just want to sort of throw this in here. This is how complicated data privacy laws are. So there's state statutes. And again, like if you have customers in a state, you're bound to it. It's as simple as that. And if you have a website, you should know where your customers are. So very complicated. Don't be intimidated by this. But again, the idea is state statutes, federal statutes that are topical, and that's more important because they take their jobs very seriously. And on top of all that, there's a agency called FTC, Federal Trade Commission, and they're the big boss, right? They're the equivalent of SEC. And they are able to regulate AI from a privacy perspective simply because of a language in Section 5. And Section 5 generally prohibits from companies from any kind of unfair or deceptive acts or practices. That's it. If you do unfair or deceptive acts, FTC could come after you. And we'll unpack how that implies when it comes to AI privacy. Some of the core privacy principles we're seeing at state as well as federal discussions and EU and around the world, they sort of have this common theme, right? They're notice, transparency. They're about giving users choice about how their personal information is used. Only collecting data that you absolutely need or is tailored to a particular use. Also providing accuracy and keeping information up to date. I didn't include it here, but in the United States and GDPR, right to delete information is an important one as well. And cybersecurity. What do you do to protect the personal information of your customers? Basically, from all the laws and regulatory discussions, they boil down to those privacy principles. So I think it's good to know them in the background. Going back to FTC, they'll come after you if you work at Google or some of the bigger companies. If you have a startup, most likely you're not going to run into FTC stuff. But let's say you work at a big company. Section 5 is very broad. And the penalty, I want to get some reactions, $40,000 for violation. You have to create a privacy program, destruction of data, you get audited, compliance reporting. Yes. And then Joon, that's like not a big deal. Like, why would I have to worry about that? You might have to delete your algorithm. Like FTC has made it clear that your model has to be shut down. And this is very similar from Bijan, our experience in crypto. Some of regulators might have you turn cryptocurrency off, right? So that's what the AI system's worried about. Like you breach FTC Section 5 egregious enough, they could come in and say, shut your business down. Don't run that algorithm anymore. So that's what we're faced with. So the primary lens that FTC uses when they're sort of going after AI companies are whether the AI company, and again, I say company because I don't know what word to use, right? There are companies who provide foundation models, there are wrapper businesses, there are, but again, like let's just say from customer standpoint, which is what they care about, are you upholding privacy commitments you made to the customers? And you might say, like, what privacy commitments? Terms and conditions, right? Privacy policy you have on your website. Those are all public promises you as the company are making to the customers. So while they don't seem very important and they're like, let the lawyers handle it, the difference between a serious consequence and not serious consequence comes down to what promises have you made in those documents. So that's important. So for instance, have you sort of drafted your privacy policy or terms and conditions so that your user data could be used for training your model? Could it be used to be shared, for instance, to an AI company? You have to be very specific because FTC is focused on this right now. And unless you err on the side of being specific, material omission could be deceptive. So that's where a lot of data privacy lawyers are spending their time on these days. And US state privacy legislature tracker, like it's going to be very hard to find one person to track all this, all at different stage, and again, underlying everything is the fact that if you have a lot of customers in, let's say, Texas or California or New York, right, it is worth maybe spending some time on what a state-specific data privacy is to A, determine if there's AI consequences, and B, even if there isn't, is there AI indirect consequences? It's probably worth having that discussion. GDPR is very different. So they have a very global framework in terms of what you need to do. We're not going to go into that detail, but they're very good at this thing, and they put a lot of teeth into it. The penalty for getting GDPR wrong is a lot of money. It's a percentage of your global revenue, or a certain amount of money, whichever is higher. So I think you're seeing a lot of big companies pay GDPR fines, which may be fine if they make a lot of money, but it could be pretty big. The idea here is that unlike the United States, this is almost a federal legislative framework that applies to anybody who does business in the EU. Okay, so I'm going to try to speed, but some of the privacy risks include for AI companies, again, did you make the right disclosure to your customers? Is your information collection, sharing, and usage exceed the original purpose disclosed? Everything is disclosure. Is your output resembling data subject? I don't know how you check for that, but we got to be careful. Or not? Could that be a matter of this disclaimer, for instance? That could be helpful. Re-identification is an interesting issue. It's coming up quite a bit these days. So even if the data is anonymized or pseudonymized, can your output be used to re-identify personal information? That's got to be very, very high stake. And then lastly, some of the other ones are unintended disclosure through prompts. So if you use a chatbot or if you use a service, is my information showing up in your result? Those are some of the key risks. I'm not going to go into too much detail here, but we all remember that case about Samsung employees sort of using an AI model and getting in trouble. How that usually plays into everyday work is a lot of people use AI for here's a confidential board presentation. Can you sort of summarize it, or can you tweak it? Where is that going to, right? Those are a lot of the things that people care about. And you got to sort of watch out for as you use these tools. Yes. And then the last one is cybersecurity. There's a whole course at Cornell on this, but the moment you use a lot of personal information, whether as part of the initial input or supplemental data, or whether you're training based on information, cybersecurity issue goes up through the roof, right? So it becomes, and SEC is one of the primary regulators of cybersecurity in the United States. Okay, so we come back to this. It's very complicated, but some of the things are, when you're trading data, are you violating IP rights based on litigation? Are you violating any privacy rights? Do you have a good cybersecurity practice and program at the product level? Where is the data stored? Where is the data going to? Where are your customers? Is GDPR implicated? State laws implicated? When it comes to the model itself, how do you deal with, and we haven't talked about this, but hallucination, misinformation, outputs that might be biased or discriminatory, is that violating any law? We'll talk about Biden's executive order. Can the model's decisions be explained, which, if people remember, could be useful if you're trying to enforce, certain IP rights. When it comes to output, do you have a defense when somebody's bringing a claim against you? Do you have a terms and conditions? What are some agreements, languages you should have in place with people you're receiving data from or sharing data from to make sure that you're not in trouble? These are some of the issues that sort of play into how a GC of an AI company will approach this, or should approach this matter. Okay, so regulatory development, I'll run through these. In the United States, President Biden's executive order came out on AI October of last year. It's not law. It's more of a call to action for regulatory agencies, recognizing some of the key important things like, hey, we need AI safety and security. Privacy is important. No discrimination. Civil rights is important. We have to understand if it's going to make people get fired. Competitive use. So for instance, if only Apple or Microsoft use it, how does that impact startups who want to use it, and so forth. Again, this is more of like a presidential statement than law, but oftentimes it could influence how regulatory agencies behave, like USPTO or SEC. So we'll have to really understand what the impact of this is, but it's more symbolic than anything. State laws, as I've said, are coming out. So this is a bit outdated, but a lot of states are coming out with specific AI bills. We have to be careful of that. 14 have become law, so we have to understand those. But I think really, given the patchwork nature of US state laws, I think, you have to have like a real conversation on, is this worth spending your money or time on, right? So again, go back to product that you're building. And are you in this zone of heightened data privacy? when you're offering your product. At that point, you should probably start off with federal statutes and then later move to state statutes if you have time. EU AI Act, super cool. First to come out with a comprehensive act on AI system. It was finalized and passed earlier this year. They do what's called they have a different spectrum, right? So again, I'm going to explain it really simply. They kind of like rank what is a high risk, what is kind of a high risk, what is a low risk, and what is a prohibited practice. So in EU, for instance, if you collect biometric data for purpose of tracking people, that's not okay. And that's just straight up illegal. But some of the higher risks could include health, safety, fundamental rights, environment, and so forth. Examples include medical devices that impact, for instance, patient health, HR and worker management tools, critical infrastructure like gas and water. What does that mean? If you're in one of these higher risk categories, you have to do a lot of things, and they include impact assessments, data governance. You have to be registered with EU database. You have to be audited. You got to have a program. You have to have transparency, human oversight. You have to be able to, justify your cybersecurity program. The details are still up in the air on a lot of these different requirements, but that's a lot of stuff. So if you have customers in EU and a lot of customers, first sort of thing you should do is, am I in this high risk area? At which point you should probably talk to the CEO and say, don't we need to allocate more money to compliance? Those are the realistic outcome. This act looks very similar from GDPR in the sense that the penalty is similar or similarly calculated. There's going to be a new regulator, which is kind of cool, an AI office that sits under EU Commission. And hopefully people in that office is from technical field that could understand and pass sort of interpretations that understand technology. I say here that the effective date of this act is 2 years, but some of the provisions are effective 6 months, which is later this year. So it's quite a comprehensive and timely act. Last one, UK approach. UK is very different. UK wants to promote technology, and they've made these principles voluntary. So they say, hey, these are the sort of the principles that we care about if you launch an AI business, and we want you to talk to UK regulators to make sure you're okay. They're sort of in the works, and again, this is outdated and I haven't really looked into it, but a lot of studies will come out, a lot of interesting research will come out. But if you're UK, they're actively trying to recruit technology businesses and sort of be scoped out of the EU AI Act, which I found interesting. Okay, so that is it. I covered quite a bit, and I hope that wasn't too overwhelming. But I think one takeaway is just, whatever you're building from a product standpoint, go back to that workflow, the product components, and just try to understand how some of these laws play into it, right? I think the goal isn't to have all of you guys be legal masters, but have that sense of red flags and know enough to be dangerous to raise your hands and say like, hey, like, is this something we need to look into? Because that could save a company down the line and, from a system standpoint. Also, as I deal with a lot of investors, some might be in startup, there's increasing due diligence on AI companies on legal and compliance, right? Because they realize that this could be a big issue down the road. So it could crop its head sooner than people think, and always good to have knowledge. That is it. I'm going to kick it back to Bijan for any follow-ups or questions.
Awesome. Thank you so much, Joon. This was a great session, and I really enjoyed it myself. I learned a few things. So people have posted a few questions. I'll kind of go over some of the maybe more unique ones, the ones that we haven't really talked about so much. So Silvio asked if you could claim authority over an AI prompt. Curious to know what your thoughts are on that.
Yes, sorry. Yes, I would like to know if someone could, claim about a prompt, or in the future some prompt could be patent or register. I don't know.
Thanks, Celia, for the question. I'm going to ask a really stupid question. Apologies. When you say prompt, what does that mean? Does that mean like what, as a customer, what I put into that gets
The chat.
fed into the LLMs or whatever models you're using?
Yeah. Okay.
It is very undecided at this time, and that's a question that nobody has asked until today. So, but oftentimes I think if you have to enter a prompt into an AI model, my guess is you're seeking some kind of a tool or a solution. So oftentimes the focus is around the output and not the input. If you could prove to whatever patent or trademark or copyright offices that the work product that you're claiming protection for is merely a prompt and hasn't gone through an algorithm, I think that's the same as not having used an AI system. So if you prove that, that's fantastic. But I haven't really come across a lot of issues on those.
Okay, perfect. So I've got a couple other questions. I'll go to the next one. So Chaitali asked, what's a good way for anybody who's starting a new project, let's say, to kind of get themselves educated on AI ethics? And I'm curious to know if you have any suggestions. Of course, one way to do it would be to take Joon's learning program on AI ethics, but other than that.
Yeah, and I'll also give you my phone number. You could call me. But it's super. It's an interesting field because AI ethics is different than AI law and regulation. So I'm going to answer two parts. First is don't let law or and this is my personal opinion. Lawyers might disagree. Don't let law or regulations discourage the product you're building. Build a good product first. And figure out the business parts, the go-to-market and everything. And then I think you want to have a high-level overview of what kind of IP, not what you're violating, right? What kind of IP do I want? And what are the data that are being used? Could those data be copyrighted? Could those be patented? Are those concerns? Those are probably the way to start from an IP perspective. And then from data privacy, as I've mentioned, a good way to kind of flowchart this is, am I collecting information of children? Am I collecting information of patients? Am I collecting information of students? There are federal statutes that govern and impose quite a bit obligations on those. So sort of figuring that out as you go along probably are what most successful AI companies do. And once you raise money and once you have critical mass and more money for legal budget, then I think you do like a very specific analysis of a particular legal issue to make sure you don't get sued or get in trouble with the regulator. And then secondly, I think AI ethics. So for one of the courses, I had this really smart lady from IBM. She was on the ethics board of IBM. And there was this like whole sort of structure that they had, right? There was the ethics board and then the committee and training of the employees. Not a lot of small to medium businesses could afford that, right? So it goes back to, what is a responsible AI? What is your definition of ethics? And for that, I think you want to do a little bit of research, right? Research into what are the latest and greatest commitments by different companies or nonprofit organizations and the way they think about what an ethical AI should be. And ultimately, I think ethics will be more important, far more important in a year or two later, because it is important now, but I think, once more people use it, there's going to be a lot more scrutiny around it.
Awesome. Thank you so much for the answer. There are more questions that are posted, but because I want to make sure that everybody gets a chance to ask a question before I go to another question from Silvio, I'll go to Anand since he hasn't asked any questions, and then I will continue if there's still time. I think we only have like 2 minutes left. So go ahead, Anand. Hopefully
very quickly. Thank you so much, Joon. I just want to understand, is there any different policy or attitude for the open sources?
Yeah. Unfortunately, not. So I'm going to try to parse this out. From IP perspective, no, it's just a factor of whether you deserve a protection. So there is no policy promoting it. I think maybe under EU AI Act there is. Certainly, I think, Sam Altman was the one who said he thinks like a good solution to some of the problems that the AI system is having is open sourcing it, but explaining it, right? Like, what is this AI system? What do they do? How are they structured? Because not everybody could look it up. That certainly is a trend that I think are picking up. But under EU AI Act or IP or data privacy, open sourcing does not necessarily equate to users understanding anything.
And Joon,
yep, go ahead.
Making sense. And we could mark as a subset of existing regulations all these legal things, right? Say, as an example, for healthcare, we are following HIPAA, and everything is there in the HIPAA is a kind of superset which include to the AI ML technologies or generative AI or LLM, etc. as well, right? So all the legal requirement which was there in terms of the existing regulatory policies would remain there. On top of that, these should be included, what you are talking of. Right?
Absolutely. I think that's the right way to look at it, right? Because from a regulator's perspective, what they care about is data, not necessarily models. So they want to know where it's going and how that's used. And at the end of the day, statute is very clear on that.
Got it. And that's the way we should, as a PM, think, Bijan, right? That what we are doing with the data.
Yeah. Okay. Yeah. So just because we're out of time, unfortunately, we're going to have to kind of cut it short. Thank you so much, Joon. This was an amazing session. And I can tell that people have also enjoyed it. A few people have posted comments, messaged me. They said they really enjoyed it. So glad to have you here. And for those of you that enjoyed the session, please continue attending our community sessions. We got another great one on trade-offs next week. It's going to be more of a workshop format. And like I mentioned earlier, on the week of June 4, we're going to be off. And then after that, we're going to continue with a bunch of additional community sessions. Thanks so much again, Joon, and looking forward to seeing you around. And until then, have a great weekend ahead of yourself. Take care.
Thank you so much, Joon and Bijan.
Bye.
What I love is the structured, the structured way of knowledge, and the beauty is, at least our instructor is the way he is structuring the information, the data, and controlling the time. It's really fantastic. I'm very, very satisfied, and it is a combination of the knowledge, which is more like information or theory, but then we are doing the workshop, and you will not you surprised, but what we are enjoying is that the surprise is practical for the PMs, right? So mostly what we think of that, okay, the workshop or the practical thing for the engineering team, this doesn't work that way, right? So right now what we are working on, say as an example, the PRD, and in parallel we are doing the little workshop as well, where we are brainstorming whether it's a particular use case is rule-based versus it should be required the LLM versus other ML model and stuff like that, right? So it's a combination, and if you are able to relate with what you're doing in your office, it gives you a whole lot of sense. And thank you so much, Bijan, because I'm sure that there's a whole lot of brainstorming with you and team has done to produce something like that. It is not just come out of the blue. It's definitely whole lot of behind the scene effort is going on. So thank you so much for you and on the entire team which is working behind the scene, right?